Welcome to Pharmasalon. This is your host, Vivian Juder-Frankel. We feature discussions on regulatory, policy, compliance, and business issues specifically for the compounding pharmacy industry. The podcast covers topics related to 503As, 503Bs, hospitals, and veterinary. I hope you'll tune into all of our discussions, as you never know when and where an idea will germinate that will take your business to the next level. We talk a lot about compliance. Usually it's compliance within the pharmacy. Today I have Darshan Kulkarni from the Kulkarni Law Firm talking about compliance with your sales team. Since there's so much information to impart, this topic is broken into two sections. During the first one, Darshan will discuss some of the key regulations regarding fair market value, the False Claims Act, and the anti-kickback law. Part 2 will cover examples of pharmacies that are under investigation, why, the fines and penalties associated with the transgressions, and how marketers can get sued for their involvement. If you would like to see the PowerPoint slides that accompany this information, you can watch the video on our YouTube channel. You can find it by typing in our name, Pharmasalon. If you have any questions for Darshan, he can be contacted at 302-252-6959 or on Twitter at @DarshanTalks. If you like this podcast, don't forget to subscribe or leave a comment. You can do so on Twitter, Facebook, or our LinkedIn page. You can also leave us a voicemail on our website.
Hey everyone, great to have you on. My name is Darshan Kulkarni. I am principal attorney at the Kulkarni Law Firm. What I wanted to get into was one of the most common mistakes that people make and what has the Department of Justice been going after because of the mistakes that are being made. So let's start with the typical and usual disclaimers. This is not intended to be legal advice. It's not intended to be clinical and medical advice, and it's intended for educational purposes only. So let's sort of take a 50,000-foot view, if you will. And the big 50,000-foot view, as we all know, is kind of obvious, if you will. Two big areas that pharmacists trip over themselves, especially in the marketing world and in the sales world, is in the bribing and the copay areas. And the good news is that everyone knows you shouldn't be bribing people. But the truth is that it's not as simple as one might think, because people are thinking about bribing in a very sort of quid pro quo. I will give you $50 for every prescription that you write from me. It's sometimes not as obvious as that. And sometimes it's people think that they're being really smart by coming up with these alternative arrangements. And if you're creating these alternative arrangements, that may not always work out. Bradley, can you hear us?
Yep.
Are you a pharmacist? Do you work in a pharmacy?
Yeah, I own a pharmacy.
You own a pharmacy, so you're a pharmacist then?
Yes.
Welcome, fellow pharmacists. Owning your own pharmacy, do you do your own marketing, and do you have other people do it for you?
I have sales reps.
You have sales reps. Okay.
Mm-hmm.
And do you have any kind of training program for them?
Yes.
Very cool. So we'll talk a little bit more about what that looks like. Do you do your own marketing, maybe?
Well, it's Lauren. As you know, yes, I do my own marketing. I act as the marketer for my pharmacy, and we had sales reps, few of them, throughout the years. Right now.
And what happened, Lauren?
To be honest, many of you know during the pain, I hate to call it the pain time, but when the pain creams were, that time.
Is this in the before times?
Yes, this is called the prehistoric time, the before time. Had some few reps out there. And then once we didn't get coverage on the creams anymore, we went back to a cash model. So I had about 3 reps out there, but just with times, and a couple of them moved on to take another job. Obviously, the industry has been impacted by the pandemic and different things like that. So I'm down to 3 reps right now.
And how do you train them?
I take them through basically a sales training. I don't want to call it a course, but they do ride-alongs with me. I take about a week to actually train them, and then ongoing training through whatever visual aids or marketing materials that I'm using. But I do a lot of in-person training where they're actually with me, shadowing, that type of stuff. That's how I would go about training them.
Right. So when you're training them, you're really talking to them about how they can do sales right. How often do you get into what mistakes can they make in terms of compliance or legal? Or is that not a core component?
Oh, that is, because especially during the time that we said it's the before time, during that pain time, we were very, very careful with what they would say, what they would be allowed to do, what they would be allowed to leave, marketing materials, etc. I had to be extremely, extremely careful and strict about protocols when they were out marketing. As of now, we're back to a cash model. I'm not dealing with insurances and things like that anymore, but still, there's a lot of legality that we have to assess often. We have to have a lot of conversations and require a lot of feedback from our sales reps, depending on situations or things they're asked, or it's always ongoing.
Yep. I think it's important to distinguish the reason why it matters, whether it's a cash model or not. And the big reason is, and I'm sort of getting to the punchline, but if the government is paying, the government's looking over your shoulder. They want to make sure that their money's going to places where it should. So there have been major problems with that in the past. And we're going to talk about some of those problems and some of those examples of those problems. So going to a cash model helps from a legal compliance perspective, but it doesn't necessarily get you completely off the hook because there are other organizations, government organizations like the DOJ and the OIG that might still have something to say about what you're saying. Also, there's the FTC and the FDA as well. So this is completely not in the slide set because you mention it. Have you heard of the FDA's bad ad program?
I haven't.
You haven't? Okay.
Actually, no.
Fair enough. No, and again, if it's one of those things that a lot of people just simply aren't aware of. And the bad ad program really targeted pharmaceutical companies for the most part. The idea was that pharmaceutical companies would go in and their sales reps would say things that were inappropriate in terms of it didn't meet the clinical standards for evidence, or they were hiding the risks, etc. But what they really did using that methodology was they quote unquote deputize the physicians and pharmacists and everyone else to understand what you can and cannot say about drugs. The funny thing is that a lot of those components associated with the bad ad program are being carried over into things like compounding. And it becomes an opportunity for the FDA to sort of share its learnings across one division into other divisions. So from CDRH into the compounding area of the FDA. Just something to consider as you are continuing to train your people. What I want to start doing is be talking a little bit about the core laws that come into play, especially when you're talking about Medicare and Medicaid billing. So the key laws that come into play is the False Claims Act, which is the FCA, the Anti-Kickback Law, which is AKL, and the Civil Monetary Penalties Law. That's CMP. There are also state laws that come into play. And when you're talking about state laws that come into play, the key piece there is that what your state allows for is something you have to consider. So for example, does your state allow for your marketing reps to walk out without being licensed? If you are a quote unquote manufacturer, according to the definition of the State Board of Pharmacy, you may need to register your sales reps. Now, the question is, as a compounding pharmacist, are you a manufacturer or are you a pharmacist? Becomes a question of, well, which one are you doing? If you're a 503A, very clearly you may not meet that definition of manufacturer unless that definition is a little wonky. On the other hand, if you're doing 503B compounding, that may very well change. So something to keep in mind as you are training your people. And then there's the last component, which is exclusion and disbarment. And the key component there is that if certain individuals have been excluded by OIG or by HHS, you are required by law to actually not enable them to be part of your facility if it does any kind of state or federal billing. And that becomes usually problematic because the penalties there are pretty severe as well. So you are required to do background checks and the like, something to keep in mind. Now, this becomes even more complicated when you start considering things like, in many cases, you have explicit requirements saying that people in your pharmacy do not use products that are without a prescription that are banned under federal laws. Well, what happens if you're dealing with individuals who are using cannabis? And that becomes a huge concern in your training program. So these are just some of the issues, and I recognize it doesn't all fall into fraud, but the implications are on fraud. And I just want you to keep them in mind as you are both hiring people, training people, and enabling people to talk to physicians on your behalf. All of this really flows around a core component known as fair market value. And whether you're paying, and Sunshine Act doesn't really apply in the case of pharmacy, whether it's the False Claims Act or whether it's the Anti-Kickback Law, are you paying too much for something? Is the government paying too much for something that they shouldn't be? And that's really the question that comes about. So what is fair market value? It's one of those things that no one really has a clear number on because there is no clear number. I'd actually taken a friend of mine who works in the Department of Justice and asked her, do we want to talk about what is a clear fair market value for, say, a pain cream? Her thing was, well, it depends on who you are. How have you done that assessment? I'm not going to sit here and tell you what is fair market value because that can change. The types of resources you use to figure this out will change. So if you are the largest compounding pharmacy in the country and you're making millions and millions of dollars worth, well, maybe you should do a better job in figuring that out than if you're a mom and pop store and you're making a good faith effort going, you know what, this is what my competitors are charging. Maybe there's a little bit more of a little bit less of a detailed discussion. Here are some definitions that have sort of come out. The IRS basically comes out and says it's the price that a hypothetical buyer and seller are assumed to be able to pay, basically. So hypothetical buyer and seller are assumed to be able as well as willing to trade or to be well informed about the property and concerning the market for such property. So i.e., they're basically coming at it from an arm's length transaction perspective. And what is fair market value? It's the price at which the property would change hands between a willing buyer and a seller when the former is not under any compulsion to buy and the latter is not under any compulsion to sell, both parties having knowledge of relevant facts. So that's 1,000-foot view perspective on this. There's also HHS, which has, and HHS, for those of you who aren't quite familiar, that's the parent organization for CMS, which lands up doing your Medicare and Medicaid billing. But according to HHS, general market value is the compensation that would be included in a service agreement as a result of a bona fide bargaining between well-informed parties to the agreement who are not otherwise in a position to generate business for the other party on the date of acquisition of the asset or at the time of the service agreement. So again, and that's a regulatory point right here, as you can tell. It's 42 CFR 411.351. The point being, you want to have an arm's length transaction. You don't want to be overcharging or overbilling for it. And you don't want to pay people off to make sure that the billing happens in a way that's not appropriate. The other lawsuit, and we've sort of hinted at this a little bit, is the False Claims Act. And what that is essentially the whistleblowers you've seen. And in the case of pharmaceuticals, we're all aware of the multi-billion-dollar fines that have been paid out. But essentially what it comes down to is these actions brought by the Department of Justice. It goes to the whistleblower key time provisions to allow individuals to bring actions in the name of the government. So when you see those $100 million fines that are being paid out, what's often happening is that the whistleblower gets to keep a huge component of that. And actually, there have been cases, and we're going to talk about them, where whistleblowers are taking components of the fines being levied against pharmacies as well. We'll talk about that a little bit further. The key piece here is that the pharmacy does not need to have had a specific intent to defraud. So it's not like you need to have gone in today going, you know what? I'm feeling like I want to defraud the U.S. government. That's not necessarily a core component of the fact that you may have actually landed up defrauding anyways. So you need to do some good faith due diligence. You need to take appropriate steps to make sure that you're not encouraging inappropriate prescribing. You need to take appropriate steps to ensure that you're not charging too much for a product that you shouldn't be. You need to make sure that you're not double billing. You need to make sure that if you bill for something that was not given, then reverse that transaction, if you will. Each of those might be a claim under the False Claims Act. Here's what the False Claims Act actually says. Any person who knowingly presents or causes to be presented a false or fraudulent claim for payment or approval, or who willingly makes, uses, or causes to be made or used a false record or statement material to a false or fraudulent claim. That all looks super, super dense. Here's the key piece of those. Number one, presents or causes to be presented. This is the key component here. Presents or causes to be presented. And the reason that matters is because if you are the pharmacist, you are the one who's actually filing the claim. Even if the doctor wrote for it, you're the one who's presenting or causing to be presented a false or fraudulent claim. And similarly, in this case, it would be the doctor might also be ensnared in this type of a situation because they would be knowingly making, using, or causing to be made a false record or claim. And so what's the penalty? The penalty to the U.S. government is $5,500, not more than $11,000 plus 3 times the amount of damages. And that's per transaction. So you might land up very quickly in the millions of dollars of liability range. So I recognize that right now we're really talking about very, very legal, detailed type of information, but I want you to get the gravity of the types of issues we're facing. The penalties can be pretty significant very quickly. What are the most common types of Medicare abuse systems that you see? So retaining government funds when there's an obligation to pay. And a good example of that, like we just discussed, is when you billed for a product, the patient didn't pick it up, and you didn't return the money back. Knowingly billing for services that were not furnished and or supplies not provided. So patient didn't come in, they didn't get it, you still billed because you'd already done it. You forgot to sort of retract that. Including Medicare for appointments that patient failed to keep. Again, if you're doing some kind of billing with individuals, so talking to patients kind of stuff, that might be a concern. Altering claims forms or receipts to receive a higher payment amount. So if you know that your product can be billed for $10 for one indication and $50 for another indication, and you just keep billing for the wrong indication, this could be problematic. Misusing codes in a claim, similar, if you will. Charging excessively for supplies or services. So if you are in a situation where you're compounding for a doctor's office, in those specific situations, you might land up saying, and the supplies are X amount. Well, that you need to make sure that is fair market value. Billing for services that were not medically necessary. So you thought that if you land up in a scenario where you can provide additional services, you land up billing the government. Turns out that those services themselves were not necessary. And then misuse grants. So let's sort of talk a little bit about the anti-kickback law, and then we'll get into real situations of what's happened already. The key difference between the False Claims Act and the anti-kickback law is there's no private right of action. So what does that actually mean? That means that you cannot sue on behalf of the U.S. government. Only the U.S. government can sue. However, a anti-kickback law violation not necessarily results in a violation under the False Claims Act. So that becomes interesting as well. Key piece again here, knowingly and willfully solicits or receives any remuneration, including any kickback, bribe, or rebate, directly or indirectly, covertly, in cash or in kind. Key piece there being, if you're part of any system, for example, Lauren is taking care of her pharmacy, and let's say we're not saying this about Lauren because we know she's training people appropriately, but let's say she didn't train people appropriately and basically went to the doctor and said that, you know what, Dr. Smith, I'm going to give you a vacation to Hawaii if prescribed $50,000 worth of my product. In that specific instance, even though no cash changed hands, the fact that there was a remuneration that was exchanged, that would be potentially problematic. And it's all about referring services or item or service for which payment may be made in whole or in part under a federal healthcare program. And then there's a lease component. So again, the other part of this that's important to recognize is that in the case of something like the anti-kickback law, I've seen pharmacists come in with more innovative arrangements, shall we say. And what that means is, you know what, Dr. Smith, how about you become a tenant in my building? I won't charge you, just direct all your patients to me. You don't have to pay me rent, or if you do have to pay me rent, I'm going to just look the other way if you don't pay your rent on time or don't give enough rent at all. That would potentially also be a violation of the anti-kickback law. Another version I've seen is where someone will say, you know what, Dr. Smith, you can have 5% of my pharmacy, or I can have 5% of your medical practice. And that can cause problems by itself because you start getting into violations of what's called the Stark law. So keep a lawyer if you need to run these things by someone. Just keep them available to ask questions. Again, you don't need to have had actual knowledge of the section or specific intent to defraud. So it all turns on your intent. And again, you want to look at the types of exceptions that may be available to you. Penalty, again, is not more than $25,000 or imprisonment for not more than 5 years or both. So if you think that you've got $25,000 to give away or 5 years of your life to give away, maybe it's not such a bad thing for you. Step by step, again, the way you want to do this is you want to identify if there's any kind of relationship. So if you are in any way able to generate federal healthcare business, including if you are a purchaser, serve on a formulary committee, or if you're a pharmacist, you may very well be subject to this. And if one of the purposes of the remuneration is to induce a reward, referral, recommendation of the business. So like we said, in the case, there's nothing fundamentally wrong about saying, Dr. Smith, I want you to be able to rent in my building. I own the building. I just want you to rent. No big deal. However, if you start looking the other way, that becomes problematic if he doesn't pay up. And here are the potential anti-kickback relationship. It might skew clinical decisions. It might undermine the clinical integrity of the formulary process. It may involve providing information to decision makers, prescribers, or patients, and the information itself may not be as accurate as you want it to be. It may actually increase the cost of federal healthcare programs, which is why they actually land up carrying. It's designed to circumvent the Medicaid rebate program, which is the best price calculation. So what that really lands up meaning is you have to Medicaid the best price, and this might be a way to say, you know what, I'm going to give you, Dr. Smith, a sweetheart deal, and that may violate the best price calculation that you have to do. And then there's a risk of overutilization or inappropriate utilization, which we talked about a little bit before. And then finally, does it raise patient safety or quality of care concerns, which if you are affecting clinical decision-making, it's likely that you'll have a claim under that.
That concludes part 1 of Compliance, Fraud, and Your Sales Team. Tune into part 2 for real-world examples of teams that have gone awry. Thank you for listening. At PharmaSalon, we produce content and conferences for the compounding pharmacy industry that focuses on learning through conversation. It is our mantra that everyone's experience is worth hearing and can benefit from someone else in the industry, and we're the ones to facilitate those discussions.